So as Rob said, we were going to focus on complex injuries and heads of claim and rehabilitation. So it is not anything, it's not scaremongering, anything like that. It's really just to equip people with the knowledge as to how these types of cases progress and the focus that we put on rehabilitation in particular. So I'll go through a little bit of the claim generally, but as many of you have heard on previous webinars, about how we actually progress cases in the first instance, I don't want to touch too much on that. So as most of you will know, we are all cyclists within the team. So we understand not only the vulnerability that people feel, but the importance to our clients of getting back out on two wheels. And that is regardless of their injuries. So there are a couple of videos within this presentation which display the real importance of cycling when it comes to rehabilitation for some of our clients. And it's amazing how there's some people that would never feel they would ever be able to get back out cycling and enjoying cycling again, but with the right equipment and adaptations, it may well be possible. In terms of complex injuries, what we're really looking at here is polytrauma. So effectively polytrauma is when someone has multiple injuries. Or we're looking at serious spinal cord injuries, so if people are left tetraplegic or paraplegic. Brain injury, where there's someone potentially now lacks capacity as a result of the significant brain injury. Amputation, and what I'm not looking at particularly in this case, but it's obviously for fatal cases as well. So in fatal cases, it's for family members to be able to make claims on behalf of the person that has sadly passed away. So that's not the focus of this presentation, but it's just to make you aware that that is a possible claim if that were to happen. So for those that have listened to the previous webinars, you will have heard us talk about the pre-action protocol multiple times, and that is really the focus of the claims that we deal with. When it comes to complex cases, the protocol does not in theory apply. So it only applies to cases up to £25,000. If the case is going to be worth more than that, which it will be in these types of incidents, then you have to get a mutual agreement with the insurers that you want to adhere to the protocol as much as possible. And really the only area of the protocol that we try and adhere to is the 12 weeks when it comes to liability determination, because that can be done regardless of the nature of the injury. But the other aspects in terms of being able to share medical reports, etc., you're unlikely to be able to adhere to the timeframes in that, but it is something that we can certainly look to agree with insurance companies. The main focus for us, and will always be for us, is putting the injured person at the centre of the process. There is no point as looking at the individual as a number, as a claim, because you will never do the best by them if that is how solicitors look at these cases. My view is that as a personal injury lawyer, it's a vocation. We want to do the best by our clients, and we need to make sure that our knowledge is up to date so that we can do that. When it comes to putting the injured party at the centre of the process, that means that we can then look at how best to get them back in the position or as close to the position they were before this all happened, because that is the focus of a civil claim for compensation. In terms of investigating matters, the initial stages will be very similar regardless of the value of the claim. So we still need to look at liability. Can liability be established? We still need to look at duty of care and all the usual things there. The difficulty in some complex cases is if there's a dispute on liability and also a dispute on what the value of the case is going to be, then you need to look at both avenues simultaneously. And therefore there is a lot of work involved there from our perspective, but it's also a lot of managing clients' expectations. We can go on about private rehabilitation, and I'll explain that in more detail later on. But if we can't get access to funds from insurance companies, we can't fund that private rehab. So we need to make sure that the client's expectations are met, and we need to be able to work out what the NHS can provide and maximise that until such time as we can establish liability. In terms of valuing these types of cases, it becomes far more complex than the kind of more straightforward injuries, more straightforward fractures, soft tissue injuries, etc. We need to rely heavily on expert evidence, and there will be a huge number of experts involved in these types of cases. What can also be really helpful is what we call documentary evidence. So often that will be, for instance, a day in the life of video. If someone has sustained a spinal cord injury, they can suffer quite badly from spasms and pain as a consequence of that. And while it's written in medical reports, it's very difficult for lay people to understand what the significance is of having a spasm. What is the impact on the actual individual? Whereas if we can get video footage showing what a day is like for them, what time the carer comes in and wakes them up, what time it takes for the carers to get them ready for the day, how they then access their home. Are they able to access every aspect of their home? Do they need help with daily living? Who helps them with that? All of that can be clearly documented in a video and is far more powerful than simply a report written in black and white that we present to insurance companies. Client testimony is also key. As I said, the client has to be at the center of all of this. So if we do not understand the impact the injury has had on the client, then we're not doing our job properly. We need to understand who they were pre-incident and what their hobbies, what drives them now, what do they want to be able to get back to, and also how those injuries are impacting them day to day. There is only so much, though, that your client will tell you. There is always going to be a need to be able to speak to loved ones, whether that's partners, children, whoever it is in their family or friends, that we can build a picture of the real impact that this has had on someone. People often put up a facade and say, you know what, I'm fine, I'm getting on with things, it's okay. And if we take that at face value, there is a real threat that their claim could be undersettled, because we say, well, you know what, they seem fine. If we believe them at that point. But once we dig a little bit deeper and speak to the bigger family group, or as I say, friends as well, we can often understand that maybe they have become withdrawn. Maybe they're no longer as sociable as they used to be because they don't feel they can be. And then at that point, we can look at what adaptations, what equipment, what experts do we need to allow them to go back into that lifestyle. In terms of the types of heads of claim we're looking at, some of these will have been talked about in previous webinars. So pain and suffering, there's always going to be a pain and suffering claim because we're looking at personal injury cases. So we won't deal with anything if there isn't an injury. So there's always going to be, we're always going to be looking at that. And we'll start off with the physical injuries, what physical injuries have been sustained. Then there's the psychological impact, and that can often be twofold, because in complex cases, they can be psychologically affected by the actual incident and potentially PTSD, things like that. But they can also be psychologically affected by the injury and how they feel they have been left. What is the impact to them psychologically now that they potentially are in a wheelchair, or they're now an amputee and adjusting to life with like that? Again, no 2 days are the same. No 2 days are the same for anybody in terms of their mental health, but it's all the more prevalent when someone has sustained a life-altering injury. So it's understanding that journey. On one day, your client might seem, you know what, I've got a very positive outlook. I know I can get back to X, Y, and Z. The next day, they might not feel so positive. So it's making sure that if you're able to, if you've got the funding, or the NHS route if you don't, that they have the psychological support as and when it is required. And it's always got to be a movable feast. There's also going to be significant financial losses. So is the client ever going to be able to return to work or return to some form of employment, if not their pre-incident employment? If they can't, then is there going to be future wage loss and also pension loss? There also might be treatment costs that they're currently incurring that we need to make sure are included as part of their claim moving forward. Medical expenses as well. Are they going to have to undergo private surgery because the surgery they require isn't available on the NHS, or the waiting list, especially now in COVID times and hopefully post-COVID times as well? It could be that people are waiting months, even years for required surgeries. So is there a medical expense? Can we look at the private route instead? And travel expenses as well, if they're going to and from physiotherapy appointments, maybe they're getting acupuncture, maybe they've got hydrotherapy, whatever it might be, those travel costs rack up very, very quickly. There's also a claim for services. So help and assistance provided to them by family members is still included here, but there may also be a care cost as well. So are they getting professional carers in? Who's providing that? What's the cost of it? And is it suitable and meeting their needs? But something or two things that are often missed out are cleaning and gardening. So is this something they contributed to pre-incident? And is it something they now need professionals in to be able to do to make sure that they can maintain the house and the garden? Because if so, those costs need to be included both now and into the future. I've got two brief case studies just to look at sometimes the kind of hurdles we come up against when it comes to liability, and also the types of injuries that we're looking at. So the first one here is a liability disputed case, and this is Ferry Road in Edinburgh. The client is cycling away from the way this image has been taken, and the third party driver is coming towards the image with the intention of turning right. The client is filtering on the offside of stationary traffic when the car turns across his path and there is a collision. At the present time, liability is in dispute, and their argument is that the car had almost completed the manoeuvre at the point of collision, which is effectively impossible given the road layout and where the other vehicles were. Often we can come up against hurdles with witnesses and what witnesses actually say they saw and what they could have actually seen. And so it's working out what would be possible for witnesses to be able to comment on and what we need to go to experts for. So the witnesses in this instance are saying they saw the cyclist going far too fast and it was entirely his fault. But a perception of speed can really only be taken if someone is traveling at a set speed, they know their speed, and someone is going faster than them. And then you can say with some certainty that the car is going, or the cyclist or pedestrian, whatever it might be, is going in excess of X speed. If you're a pedestrian and you're walking at maybe 2, 3, 4 miles per hour, your perception of someone going faster than you is just that, they're going faster than you. Do you know if they're going 15, 20, 25? And therefore, what we need to look at actually is expert evidence. What expert would be able to comment on potential speed, sight lines? What should the driver have done in this instance? Would the cyclist have been visible to them? And then we can build a picture in respect of liability. When it comes to the injury side of things, this particular client has sustained neck fractures, facial fractures, and dental injuries. But what we need to focus on is how we then instruct experts in this case, because the nature of the neck fractures meant he had a neck brace on. So there's no point in sending him to a dental expert when he can't recline in a seat. He's not comfortable. We need to make sure we've got the spinal surgeon, we've got the report from them, we know the nature of the injuries, and we know how long it's going to take for him to recover. At that point, we can then look at a max fac specialist in respect to the facial injuries and a dental expert in respect to the dental injuries, and progress from there, because this client couldn't see his dentist until such time as his neck fracture had healed. He's also self-employed. So what's the impact on his work? He had to go back to work far earlier than he should have done, because if he's not working, he's not getting paid. And what we need to make sure is that that doesn't then have a knock-on impact to his claim, because you will get insurance companies that turn around and say, well, he was back at work within 3 weeks. The injury couldn't have been that bad. But if someone is not earning, then they'll have a drive to return to work far earlier than they should do, because they have no way of paying their mortgage, paying their bills, and everything else. So it's understanding the client and understanding the impact on them that we can then best present their case. And it's also looking at overlapping experts. So because the nature of his fractures, was an orthopedic specialist ever going to be suitable? My view was no, we needed the spinal expert and then a max fax in respect of the facial fractures. We needed two separate experts because they were complex injuries. The other side of this is a similar type of injury, but where we've got a full admission of liability because the client is hit from behind. And what we did here is we've had early engagement from the insurance company, and we have a case manager involved who then liaises with the client and with both the insurance company and with me to make sure funding is in place for anything that client requires. So physiotherapy is set up, and also in the background, there's a discussion around psychological treatment. At the present time, the client doesn't feel that they need it, but if at any point that deteriorates or they feel that input would be of benefit, we're able to get the funding in place very, very quickly and for that to progress as and when they feel it's necessary. But the injuries here, again, we've not got to the stage of instructing experts, but there is going to be a significant overlap because the internal injuries include damage to the liver and damage to the kidneys. We also have neck fractures, which again resulted in a collar, and then rib fractures as well. So we need to look at who can provide an opinion on what here and at what level we need to start instructing them. So the internal injuries, they have actually healed fairly well, and it's more the fractures that are now causing the issues. So it's then looking at what point during the recovery process expert instruction is necessary. And by comparison to the previous case study, this client is paid in full while they're off work. So there's no rush to get back, but equally, they're very eager to get back as part of their recovery process. So that's something the case manager can work with them, speak with occupational health, and make sure that it's suitable for them to return as and when they feel necessary. This particular client also has a young child, so it's the impact on the whole family dynamic. She had to deal with homeschooling, and do we need to provide any support in that situation as well? That's something that's always got to be in the back of our minds as the solicitors, so that we can then best instruct the people that are involved in the case. In terms of the role of a case manager when it comes to rehabilitation, we need to make sure that they're instructed early on, and in a case of admission liability, that they're funded directly by the insurance company, because that means that they can provide input as to what rehab is required for the client and at what stage. They then make their request for payment directly to the insurance company, and payment can then be released. So they're integral and sit kind of in the middle beside the client during the process, because it needs to be a multidisciplinary approach. In terms of rehabilitation in the community, there is obviously so much that the NHS can do. Beyond that, we need to look at what can be privately funded. And this is a short video of a client of mine. It was actually a motorcycling incident that he was involved in, and he is now an above knee amputee. He was 19 at the time of the incident, and he was discharged from the NHS rehab facility with a very ill-fitting limb. He'd lost all confidence in being able to use his prosthetic and was effectively confined to his wheelchair. He'd also become completely disengaged from rehabilitation because the NHS rehab facility was really people that had fallen, fractured hip, etc., and they were age 70 or above. So he was not willing to engage with the NHS side of things. Because liability was admitted, we were able to get private funding for a microprocessing limb, which I'll go on to speak about, but also physiotherapy in the community, which was key for this individual. So just a matter of weeks prior to this video, he was effectively confined to a wheelchair and did not really see a way forward. But because of rehab in the community, he is now out enjoying his e-bike. I'm told there's also videos of him doing wheelies and all sorts, but I'm never too sure about putting them on public forums in case insurance companies come a-knocking. In terms of the journey to recovery, that's something that we need to take the client on, because there will be times along the road where they do become disengaged and they can't see the wood for the trees. They don't understand why they're having to see so many experts, or why the insurance company aren't funding something that seems really straightforward. So it's making sure that the client understands the full process and why things are being done along the way. Because, as I say, at the end of the day, is we want to try and get them back as close to the position they were pre-incident, which is obviously impossible when you're looking at spinal cord injuries, amputee, brain injuries, etc. But with the help of equipment, adaptations, etc., it can be possible to get someone back to an independent lifestyle. When we're looking at instruction of medical reports, we need to think what specialty is going to be important, or specialties. There's often, as I say, multiple crossovers that we're looking at. So we might be looking at a neuropsychologist if there's like chronic pain symptoms that are ongoing as well, orthopedic experts, cardiologists, psychiatrists, respiratory physicians, pain consultants. The list really is endless. We often have to look at general surgeons, renal surgeons, you name it. And anytime a new expert comes into play, we want to learn more about that. What is their speciality? How can they help us? How can they help our client? And it's from our perspective, we're reaching out to these experts on a continuous basis and saying to them, can you come and do a webinar to us? Can you explain to us your area of expertise? Why it's important to instruct you? At what stage should we be instructing you? Because if we make sure our knowledge is constantly up to date, then we can then make sure that we can do the best by our clients as well. In terms of the kind of scheduling side of things, there are such things as super specialists, which some consultants like to be called. So it's knowing if that is applicable. So sometimes the neuropsychiatry route, that can become a bit of a super specialism when they're looking at particular chronic pain symptoms, things like that. But what's always going to be key in complex cases is looking at an employment expert. Is it going to be possible that this particular client can get back to any form of work? If the answer is they will never be able to earn anything ever again, then potentially an employment expert isn't required. But from a psychological standpoint, it may be important to still look at voluntary work. Are they going to be able to do any voluntary work that will make them feel needed and wanted back in society? Pension expert is going to be required in any case where there is wage loss into the future, because there most likely will be pension loss as well. A needs and care expert is key, and sometimes what we need to do is instruct that alongside an occupational therapist as well, to understand what our clients' needs are in respect of adaptations at home. So smaller adaptations that are going to be required, equipment that's going to be needed. There are hand cycles, for instance, if you've got someone with a lower limb injury, that keeps them motivated, keeps them being able to do exercise on a daily basis, can work on spasms, things like that. So is that something that would be of benefit to your client? But also looking at the care side of things. So if we have a liability disputed case and there is care in the community, what more would be expected if there was private funding in place? Do that person need 24-hour care, but it's just not currently feasible? If so, do they need a live-in carer? Do they have carers that can just come for a few hours per day? What is needed for that particular individual? And a lot of it will come down to the family setup as well. Orthotics can also be key if someone has what's called a foot drop, so they're not able to lift their foot properly anymore and walk. An orthotic might be a tool to allow them to get back to walking. But it also can be used on a slightly more basic level if someone has a femur or pelvic fracture where there's then a leg length discrepancy. I had a case recently where a client had fractured femur and ended up with a leg length discrepancy. He was in his 30s and the private orthotic provision was £25,000 on its own. And that was just making sure that he had specially adapted insoles to allow him to walk without the need of a walking stick. In his 30s, he didn't want to walk with a walking stick. While it might have been possible for him to do so, we were able to look at what other adaptations could be done and what equipment could be used so that he could get back walking with a semi-normal gait. When it comes to equipment and adaptations, we need to understand who our clients are and what they did pre-incident and what they want to achieve now, because there are obviously always going to be limitations. There's no disputing that. But with the kind of Paralympics, things like that, there are a lot of sporting activities that we can look at that may be able to be adapted to spinal injury patients, certainly amputees, etc. But it's understanding what drives the client and what they have an interest in, and then we can look at what equipment is out there. Because if someone has done it, then there is going to be a basis for that equipment. There are adapted bikes, there are adapted motorcycles, you can go out sailing, even if you've got a high spinal cord injury. There are so many different routes that we can go down, but if we don't understand what our clients' goals are, then they can't be included in the claim. So we need to understand the basis for that first. We then need to build instructor experts to provide comment on, is it going to be appropriate for this particular client, and what is the cost implication going to be for them as well. One such piece of equipment that is certainly out there on the market and we can look at for spinal cord injury patients is the cyclone. So this is a way of them getting back out on a bike to some degree, mountain biking in particular, and getting them that feeling of adrenaline and things again that they may have felt was never going to be within reach. So hopefully, the sound might be slightly funny, but hopefully this video will play without too much difficulty. So it's just an example of how there can be adaptations out there to allow people to go back to the hobbies they had pre-incident while in an adapted way. So I mentioned previously that the protocol doesn't really, we don't adhere to it so much in complex cases. What we do have is the rehabilitation codes, the code of best practice, which not all insurance companies are signed up to, and is something that's used far more south of the border than it is in Scotland. But what happens under the code of best practice is if there's liability is admitted, or certainly primary liability is admitted, the insurance company have to engage with rehabilitation. In respect of any civil claim for compensation, it is the pursuer's duty to mitigate their loss. And what we will always argue is the only way to adequately mitigate loss is if we can get early intervention of rehabilitation. So that can usually be done by an initial or an immediate needs assessment. And it's normally an OT or a nurse that carries that out. And then they provide a report detailing what that client needs in the immediate vicinity. So are they looking at physiotherapy? Are they looking at counselling? Are they looking at acupuncture? What is it they need to be able to live a fairly stable life at home? Do they need a ramp put in place to get into their property, for instance? Do they need a handrail put in? All that type of stuff, it's all going to be detailed within that initial needs assessment. But also, is it appropriate to have case management moving forward? So as I mentioned, the case manager is integral to making sure that rehabilitation is in place along the way when it comes to progressing the claim. And they all, if they're jointly instructed, which they usually are in Scotland, they have to feed back information both to us and to the insurers. But it's not always going to be appropriate. So case management fees in a complex case can be anywhere between £10,000 and £20,000 a year. So it's not going to be a cost that insurance companies are going to pay unless it's required. And it's for us to prove that they should be required. When we're looking at amputees, this is an area that is of particular interest to me because I find the use of technology really quite fascinating. So the cases that we've had as a firm have all been of below, lower limbs. So we've not yet dealt with an upper limb amputee. And the four images on the screen here are all looking at microprocessing knees. So for above knee amputees. Our job is to know what is on the market and what may be suitable for our client, and how do we find out what is suitable? Because it's not always a case of going, well, we go for the most expensive because it's the best one on the market. It may not be something that they require. So the Genium X3 is the most expensive currently microprocessing knee option. And the main reason for that is the fact that it's waterproof. But if the client doesn't want to do anything that would involve water, whether that's, for instance, mountain biking in the rain, kayaking, things like that, gorge walking, then it might not be something that's suitable for them. And it may be the cheaper option of the Kenevo is going to be a better fit. The only way we will know that is by instructing a prosthetist to carry out an assessment and tell us what is the best fit for the client. There's an argument in Scotland that there is provision within the NHS and therefore that should be suitable. What happens south of the border is often amputees are discharged with no limb, and it's a matter of 12 months, 18 months, 24 months down the line, they may get something. But in Scotland, they do tend to get discharged with a limb, and they make sure, the physios make sure they can stand up, sit down, walk up steps, etc. But what we find is we deal with highly active individuals, and that's not good enough for them. they want to be able to get back to a high level of activity, and microprocessing limbs allow for that. With that in mind, our focus, if at all possible, is looking at collaborative working and moving away from this mentality of them against us when it comes to insurance companies. Yes, insurance companies want to reduce down the cost that they have to pay out at the end of the day. But if we work together, then the cost can be reduced all around. Because if we can get the client back to potentially employment, or if not, then reducing down what their care requirements are going to be, then that saves the insurance company money, but it also gives our client a far better standard of life. And that's got to be the key to everything that we do. We had a case that ran to proof. It was a motorcycling case in 2014, and that was the case of Adam Wagner against Thomas Grant and another, and it involved a 17-year-old who was a below-knee amputee following a motorcycling incident. And the case ran just on liability and the provision of prosthetics. And our expert had suggested that Mr. Wagner would benefit from a microprocessing ankle. But under cross-examination, he admitted that it would be the Rolls-Royce provision. And as a result, the judge, Lord Ewis, decided that that was not what Mr. Wagner was entitled to. It is our view, and the view of majority of the legal profession in Scotland, that was wholly inappropriate and plainly wrong. The individual should be entitled to the Rolls-Royce if that's the description they want to use. As I say, the whole premise of what we do is to try and put someone back in the position they were had it never occurred. And therefore, if there is technology to allow someone to do that, they should be entitled to claim for that. There hasn't yet been another case in Scotland that's run on prosthetics, but there have been a number south of the border, and certainly we've had cases that have settled now on the basis of what's happening in England and Wales instead. And we would certainly be looking at always including the Rolls-Royce, if that is in fact what the prosthetist recommends for that particular client, depending what activity they want to return to. One thing we did learn from the case of Wagner is how important it is for our clients to be able to test any equipment that we're claiming for, really. But really, when it comes to the provision of prosthetics, if the client has not tested the limb and cannot say, this is the limb I wish to purchase, then it may be a court won't award that. When you're looking, for instance, at the Genium X3, just to purchase it, this isn't looking at future costs, you're roughly about £80,000. So if you want to be able to include that as part of the claim, then if liability is admitted, get the limb purchased, get your client using it. But if it's not admitted, then at least get them testing the limb, make sure it is a good fit for them, because then it's going to be far easier to be able to prove to a court that that's what's required. There's also savings longer term as well, because if they're back out using that limb, then they'll be back doing far more kind of, as I say, potentially back at work or certainly enjoying their hobbies, which then has a knock-on impact to the psychological side of things as well. When we're looking at spinal cord injuries, often we can look at the help of private rehabilitation hospitals. Sadly, we don't have any in Scotland, but this is the Royal Bucks Hospital in Buckinghamshire. Again, it's not cheap. You're looking at tens of thousands a week for rehabilitation at this facility, but it is intense rehabilitation. And if we're able to get direct funding from an insurance company and we can show it will be of benefit to a recovery, then it is something we'll push for. We have had a client who spent a lengthy time down here who had suffered from a condition called ICU neuropathy, where although he didn't have a spinal cord injury, he had limited to no movement below the neck as a result of this condition. Because of his stay at this hospital, he's now reduced down significantly the care requirements that he has both now and into the future. He's able to brush his own teeth. He's able to hold a pint and drink a beer and do a lot more with his hands, which in turn increases his quality of life. But as I say, also decreases his care requirements, which is music to insurance companies' ears. Sometimes care needs can be far more basic than prosthetics, things like that. It doesn't have to be all singing, all dancing. To give someone independent living, you could be looking at a simple Alexa in someone's home, or a camera doorbell that allows them to speak to someone at the door without having to go and answer it. It's looking at what technology is available simply on the open market, and what technology is slightly more complex that you then need to look at an assisted technology expert. The more basic technology can be dealt with through occupational therapy assessments. You can get remote control hoovers, lawnmowers, and people have those in their home without the requirement for them, but it simply brings joy, I imagine, if you don't have to hoover every week, if you have something else that does it for you. So that type of technology is already available, but if it would benefit our client, then we can look at having that included. The other thing I've had included in a number of cases is automatic garage doors, where someone's injured their shoulder and can no longer reach above head height, so they can't open and close the garage door. And rather than having to rely on someone else in the home, or potentially they live alone, then an automatic garage door gives them that independence. So it's just looking at what type of technology may be of benefit to that individual and getting the correct experts involved. Is it an occupational therapist, or is it an assisted technology expert? There's also different types of therapies that may be of benefit for particular clients. Neurophysiotherapy can be key for some with spinal cord injuries, as can hydrotherapy. So where are the hydrotherapy pools? There are, certainly not one that I've dealt with, but there are cases where hydrotherapy pools can be built into someone's newly adapted home if it is suitable. But you will only know that if you have medical experts and other experts that can say that is their requirement. In terms of housing, what we need to bear in mind is cost implications. So we need to understand, where does the client currently live? Is it going to be feasible for them to be able to adapt their current property, or are they going to have to live in an entirely different property? Will that property have to be built from scratch, or can we adopt a pre-existing, can we purchase a pre-existing property and then adapt it from there? We have had clients where pods, which are shown at the bottom of this slide, they're effectively almost pre-built and then delivered to the property. So it's a completely separate structure. And if someone has the land to be able to do that, that can set up, you can have a gym set up there, you can have rooms for the carers, breakout space for the carers, all of that type of thing. Whereas it may be appropriate that a whole build needs to be orchestrated for the particular client, depending on their needs and depending on the level of disability. So we've had to look at this with pre-existing clients and had to work out what the best fit's going to be for them. It's not for us to say that. We do need to instruct architects, and the architects need to work with a whole host of other experts involved in the case. So the occupational therapist, the care and needs expert, they need to look at the medical expert reports as well. What is going to be suitable for this client now, but also in the future? If we're looking at somebody who has a spinal cord injury in their 30s, are they going to need more care as they live longer? Because if so, then it may be that we need to design a property that has an additional bedroom for live-in carers as they get older. But we won't know that unless we've asked the questions from the correct experts. The other great thing that we can look at, and this is whether liability is disputed or admitted, is support groups. There are a whole host of support groups out there that are funded, are charities. So we don't need to have funding in place by insurance companies. There is, for instance, Cycling UK have the Edinburgh All Ability Bike Centre. I've had clients that attend that in order to get back out on bikes following injuries, and they get support through that, and it's all charity based. I know that they are struggling at the moment with funding, but it is something that we can look at. Also with the Spinal Injury Centre, there's Horatio's Garden, which is at the Queen Elizabeth University Hospital Spinal Injury Unit in Scotland, and looking at the benefits of being able to get out in the garden and work in that as well. So that's another fantastic charity from the spinal injury side of things. But we just need to look at the physical, psychological and emotional benefits of the different types of therapies that are available. I have had a client, for instance, who has attended a Buddhist centre down in the Borders that was a couple of £100 for a retreat, but it was an escapism from his young family. He was able to give his wife respite because of the nature of his brain injury. And he was also able to meditate and do various things that were of benefit to him, but not at a huge cost that you see from a rehabilitation hospital south of the border. So there are different avenues that we can look at if funding is going to be an issue. And it's just knowing what is out there, knowing what charities may or may not be able to help. Headway is another one if we're looking at head injury cases. Do have a short video from Cycling UK in respect of the Edinburgh Liability bike set.
So we'll use a range of adaptive bikes to help people get going, and that includes people with neurological conditions, learning disabilities, physical disabilities, age-related conditions, acquired conditions such as stroke or MS and things like that. So I'm David Glover, I'm the Senior Development Officer for the Edinburgh Liability bike set. Cycling is beneficial to the people who come and use our bikes as it is for anyone else. You've got the health benefits, the physical health benefits for getting out, getting active, fresh air, exercise, the mental health benefits and social benefits, getting to meet new people, and just the feeling they get when they're riding with other people and being part of.
Thank you. So just to kind of wrap everything up with this presentation. So what happens if this happens to you? This is a slide you've seen in, I think, all the previous webinars, and we certainly hope it does not. But the hope from these webinars is that it's given you knowledge as to what we do on a day-to-day basis, and also how these claims do progress. So if it does happen to you or someone you know, do get in contact with us. We're always happy to give free advice and talk people through if we can help them. If we can't, then we can direct them elsewhere. Or before anything happens, if you want any advice on how to stay safer on the road, give us a call and we can see if we can help you there as well, because we do want to see ourselves very differently than other personal injury firms. We want to be kind of forward thinking when it comes to a road safety perspective. We want to reduce down the types of road traffic incidents that are occurring. And as many of you will know from the campaign on presumed liability, that is something we are pushing for and are extremely dedicated to getting in Scots law. And that is the end of all of our webinars and today's presentation. So I think there have been a few questions as we've gone along. But obviously, if there's any more, then you can write them in and I will see if I can answer.
We've got a couple of questions through the chat and one on the Q&A. I don't know if which one you want to handle first, Jodi. Can you see the Q&A from Ray?
Yep. So if a claim for negligence arises and the injury is as a result of an old healed injury becoming aggravated, how does the court view this? E.g. healed cracked ribs, tendon, tissue. I've had them all, gosh. Okay, so in terms of pre-existing injuries, that is something that we will always ask the medical experts. So we get the medical records in and we'll look through those. Are there any injuries there that we need addressed? So if, for instance, you've fractured your ribs again and you've previously fractured them, we can ask the expert, is there any ongoing issue as a consequence of the pre-existing injury? The most kind of common ones we see are joints. So knee, shoulder, elbows. We also get back and neck injuries that are pre-existing. And we then just ask the expert, has this been aggravated? And if so, what are the implications in respect of duration of symptoms? The other thing that can happen is some people have asymptomatic issues. So it may be you have degenerative changes in your neck or your back that you were unaware of, but then as a result of a collision, you start having symptoms. And it's for the medical expert to say they have been accelerated by X time frame, and then we value it on that basis. So the court, at the end of the day, the way that these cases work, you take your victim as you find them. So it does not matter what injury you've sustained previously. If that has been aggravated, it must be included as part of the claim.
Hope that answers your question, Ray. Andrea's asked, do we find that someone is more likely to admit liability if the injured cyclist is female?
No, is probably the most straightforward answer. So we have a lot less clients that are female just because of the demographic of cycling in Scotland. But gender alone will have no bearing on whether or not liability is admitted. I'm not even convinced insurance companies look at that, to be honest. I'm not aware of any trend with regard to gender. What we sometimes see is potentially if insurance companies look up types of bikes, then you might get, if it's a road bike, they start kind of digging their heels in about speed, etc. They like to use the expression road bikes are built for speed, but obviously it all depends on who's riding them. But I haven't seen any kind of statistics or trends, is probably the better word there, Andrea, for me, in terms of females and male ratios, I'm afraid, or not, as the case may be.
I don't think I can comment further from what my information I've got had either. Another question she asked was, what has your largest claim been?
So in terms of obviously all our different branches of the firm, in terms of cycling side of things, we had a claim, the highest one we've had, I think at the present time, is about 1.5 million. From road traffic incidents, it's closer to the 4 million, and motorcycling, it's close to 4 million as well. But usually what that comes down to is care costs and future wage loss. The actual injury side of cases, you don't get a huge amount for. It's the future losses and then applying interest to them and everything else that tends to rack up the costs into the millions.
Brilliant. Thank you for that, Jodi. Any other questions out there? You've got 10 seconds to throw a question at Jodi. Perhaps your thorough presentation, which I found extremely interesting, Jodi, has answered all the questions they may have had. Looks like we're there. All it really requires me to do, I guess, is say thank you, first of all, to you, Jodi, for tonight, for our brilliant presentation. A great way to finish our series on. Thank you for that. And to all of those who joined us over 1, 2, 3, 4, 5, 6, 7, or 8 webinars, and I will look at the statistics, and there could be prizes for those of you who have done more than 6 or 7. There could be some Cycle Law shirts heading in your way. Watch this space. But I hope you seriously have all enjoyed it. I hope it's found useful, and hopefully you'll never need our services. But if you do, we will be delighted to speak to you and help you all we can. Thank you once again. Good night.